Congress has just issued a direct order to the Attorney General demanding an immediate halt to enforcing NFA registration requirements. What's unfolding right now has the potential to tear down almost 100 years of federal firearms regulations. We're discussing suppressors, short-barreled rifles, and short-barreled shotguns, items that have needed federal registration since 1934, and they might become entirely unregulated in just a few months. These congressional letters contain information that could transform the entire landscape of gun rights in America. Let's examine what Congress is actually demanding and understand why the legal basis for NFA registration has suddenly crumbled. Before we get into the details, I need you to do something really quick. Smash that like button right now if you care about protecting your Second Amendment rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. Something major happened on July 4th, 2024, that almost everyone overlooked while a 1,000-page spending bill was being passed. Buried in that legislation was Section 70,436, which quietly dropped the NFA tax stamp from $200 down to $0 for suppressors, short-barreled rifles, and short-barreled shotguns. That $200 tax had stayed exactly the same since 1934, sitting unchanged for 90 years straight. Think about what that means when you account for inflation. If that tax had been adjusted normally over time, it would cost $4,600 today. The government was basically making you pay nearly $5,000 in actual buying power just to exercise what many consider a constitutional right, and their justification was simply calling it a tax. For decades, Americans have paid this fee more than 15 million times total, creating hundreds of millions in government revenue while simultaneously building a huge federal database of gun owners. The ATF handled about 2.5 million Form 4 applications in 2023 by itself, with each application taking around 200 days on average to get approved. But here's the crucial part that nobody seemed to grasp when that tax got reduced to zero. The entire legal justification for requiring any of this registration process just vanished into thin air. Back in 1937, the Supreme Court made a ruling that registration was only constitutional because it helped with collecting taxes. Now there's no tax left to collect. The members of Congress, who actually wrote Section 70,436, didn't just stay quiet about their intentions. They sent official letters straight to Attorney General Pam Bondi, spelling out their position in words so direct that there's absolutely no way to misunderstand them. These weren't gentle suggestions or friendly requests. These were clear, explicit instructions about how the Department of Justice needs to handle every single lawsuit that's challenging NFA registration right now. What makes this truly remarkable is how rarely Congress steps in this directly when litigation is already happening. The people who sign these letters include committee chairmen and senior members who hold genuine legislative authority, individuals who control budgets and have oversight power over the exact agencies being told to back off. The letter makes specific reference to the Sinsky Supreme Court case from 1937, which happens to be the exact same case the government has relied on for decades to justify mandatory registration. By bringing up this case themselves, Congress is essentially using the government's own legal reasoning against them. They're making the argument that the courts already settled this question 90 years ago. Registration only holds up legally if there's a tax connected to it, and since you got rid of the tax, the registration requirement has to disappear too. The DOJ is now stuck in an impossible situation. They can either follow what Congress clearly intended and drop registration requirements altogether, or they can fight Congress in court while trying to defend a position that directly contradicts what the legislative branch explicitly stated they meant. The legal theory might be interesting, but the sheer number of lawsuits already moving forward makes this situation incredibly volatile. At this very moment, there are at least 8 major federal lawsuits challenging different parts of NFA registration, and every single one just received powerful new evidence to support their case. Gun owners of America filed what they're describing as the one big beautiful lawsuit, going directly after registration requirements for items that now have zero tax attached. The Firearms Policy Coalition is pushing 3 separate cases through different circuit courts simultaneously. These aren't small lawsuits filed by individual gun owners acting alone. These are enormous organizational efforts supported by millions of dollars in legal funding and teams of expert constitutional lawyers. The Fifth Circuit by itself, which has shown growing resistance to gun regulations following the Bruin decision, could issue a ruling that impacts 37 million people living across multiple states. Judges put heavy weight on legislative history and what Congress actually intended when they're interpreting laws, and now there's an official letter stating that registration shouldn't exist. Some legal experts are making estimates that if just one appellate court rules that registration is unconstitutional for items with zero tax, it could make 8.2 million existing registrations invalid immediately. That doesn't even include the estimated 2 million people every year who wouldn't need to register going forward. The ATF currently employs 2,800 workers whose job is specifically processing NFA paperwork, running background checks, and keeping the registry updated. That's an entire bureaucracy that might become completely unnecessary if these lawsuits succeed. While courts are working through legal theories, something strange is happening right now at gun stores and with manufacturers. Suppressor manufacturers sent out 2.6 million units in 2023, the biggest number ever recorded, and every single one of those required a $200 tax stamp and months of waiting time. Right now, those same manufacturers have inventory sitting there worth hundreds of millions of dollars, and nobody has any idea what rules will be in place next month. The industry brought in $1.4 billion just from suppressor sales last year, and that doesn't even count short-barreled rifles or shotguns. If registration requirements go away, analysts are predicting the market could grow 3 times larger within 2 years because the obstacles to buying one drop to nothing. Currently, purchasing a suppressor means finding a dealer who has a Class 3 license, completing ATF Form 4, getting your photo taken, getting your fingerprints done, waiting 200 days on average, and crossing your fingers that you don't relocate to another state before your approval arrives. Take away all of the hassle and suppressors become as simple to purchase as any other firearm accessory. Some manufacturers are already increasing production right now in preparation, constructing new factory buildings and bringing on additional workers. The economics are creating chaos, but the constitutional argument that hardly anyone is talking about might actually be the most significant aspect of this whole situation. Sinskey v. United States in 1937 wasn't really focused on gun rights at its core. It was about whether Congress had the power to use taxation as a way to regulate behavior. The Supreme Court decided that yes, Congress can put heavy taxes on things to discourage certain activities, and yes, they can require registration to make sure that tax gets collected. That ruling has been referenced in literally hundreds of cases over the last 87 years to justify all sorts of federal regulations. But here's the critical detail about that decision. The court specifically stated that registration was constitutional because it was an appropriate way to enforce the collection of revenue. Not public safety, not preventing crime, revenue collection. The whole legal justification was about money, not about regulation. Jump forward to today, and there's no revenue left to collect anymore. The tax is zero. Using the Supreme Court's own reasoning in Sinskey, the registration requirement just lost its constitutional foundation completely. Legal scholars are describing this as a self-executing repeal, which means the law automatically becomes impossible to enforce when the constitutional reason for it disappears. The government can't suddenly start arguing public safety now because they never made that argument before. Some lawyers are drawing comparisons to prohibition. When the 21st Amendment repealed the 18th, all the laws that enforced prohibition became void automatically. Nobody had to file lawsuits or sit around waiting for court decisions. The Bureau of Alcohol, Tobacco, Firearms, and Explosives has 5,111 total employees and operates on an annual budget of $1.7 billion. A major chunk of that budget and workforce exists only to run the National Firearms Act programs. The NFA division handles millions of forms, performs hundreds of thousands of background checks, keeps a registry of every legally owned suppressor and short-barreled weapon in America, and carries out compliance inspections on tens of thousands of dealers. If registration goes away for the items that get registered most often, roughly 40% of the ATF's work disappears immediately. Government agencies don't willingly make themselves smaller. They fight to survive. The ATF has already put out internal guidance telling field agents to keep processing forms and enforcing registration requirements even though the tax was eliminated. They're operating as if nothing has changed, even though the constitutional basis for their authority just disappeared. Some people are still registering suppressors just to be safe. Others are refusing to register, gambling that courts will agree with Congress. The ATF is trapped between what Congress intended, the court challenges coming at them, and their own organizational interest in keeping their power intact. The question isn't about whether the ATF wants to maintain registration. Obviously they do. This represents the most important Second Amendment development in almost 100 years, and how the DOJ responds over the next few weeks will decide whether millions of Americans get back rights that were taken away in 1934. The situation is moving incredibly fast, and what happens next could reshape gun regulations across the entire country. The combination of congressional pressure, multiple lawsuits, Supreme Court precedent, and the elimination of the tax creates a perfect storm that the ATF and DOJ have never faced before. The registry that took 90 years to build could potentially disappear in a matter of months, and the implications would be massive for gun owners, manufacturers, dealers, and federal agencies alike. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one.